a very warm welcome to this London International Disputes Week members hosted event hosted by Brick Court Chambers and Hausfeld. I'm Ned Beale, a litigation and arbitration partner in Hausfeld's London office. The topic of this session is interventions in the Supreme Court, with a particular focus on the dynamics where a public interest intervention is made in a commercial case. Now, what I hoped for when I started to pull together this session was to have a panel who could give a range of views from the bench, from an intervener, and from counsel. And happily, I've ended up with a panel who really couldn't be better qualified. So I will introduce them without further ado. From Brick Court, we have Lord Hoffmann, whose name and judgments will be known to everybody, as will, I'm sure, his more recent practice as an arbitrator at Brick Court. From the UK's leading consumer rights organisation, Which, we have Lisa Webb, who's a senior lawyer there. Lisa has experience of intervening last year in Merrick's and MasterCard, and of course, Which also intervened in Parking Eye and Beavis, which the Supreme Court set out the modern law on penalty clauses. And last but not least, from his own chambers, established last month, we have Philip Shepherd QC. Philip is no stranger to the Supreme Court, having acted before a panel of 9 in Patel and Mirza. Last autumn, Philip was on for the appellant in the economic duress case, Times Travel and Pakistan, in which he faced interventions from 3 parties, the State of Ukraine, Lord Venture Trust, and my clients, the All-Party Parliamentary Group on Fair Business Banking. As a short preface from me, the idea for this webinar came about because I had acted for the All-Party Parliamentary Group in Times Travel, which is very much a private law commercial case, but we were making submissions on a public interest point, namely to protection of bank consumers. And similarly, my partners at Hausfeld had acted for Which to intervener in Merrick's with a similarly pro-consumer role. And I suppose that I thought that was quite unusual, that interventions more normally would have preserved of human rights and public interest cases. However, looking at the Supreme Court's caseload in 2020, that's not the case. I did little number crunching to prepare for this seminar, and out of 53 Supreme Court judgments in 2020, 16, so about 30% featured interventions, and that's about average. Out of those 53 judgments, 21 were what I would call commercial judgments, and of those, 8, or 40%, featured interventions. So the upshot is, at least last year, you were more likely, rather than less, to encounter an intervention if you took a commercial case to the Supreme Court, as opposed to a public law or criminal law case. So with that in mind, what I hope we can do over the next hour is look at some of the issues that can arise in interventions in private law cases. What I'd like to do, with the benefit of the panel, is to cover 3 broad topics. First, how interventions influence judicial decision-making. Secondly, how interveners can maximise their input and impact. And thirdly, practical tips for counsel and solicitors dealing with interveners. We plan to structure this as a discussion, both between the panel and hopefully with the audience too. To that end, please do send questions and thoughts via the platform. They will be relayed to me, and I'll do my best to relay them to the panel. So, on to the first topic, how interventions influence judicial decision-making, and do they make better law? Lord Hoffmann, it would be great if you could give some insight on this from your experience.
Well, interventions can influence judicial decision-making if they bring something new to the table. That is to say, if they provide the tribunal, in this case the Supreme Court, with information about the possible consequences of their decision, which they would not have been able to obtain from the parties. And this is not, I'm slightly surprised to hear the figures which Ned has just read out about the proportion of cases in the Supreme Court in which there had been interventions, because my experience was that it was quite unusual, though very valuable when it happened, for an intervention which was provided the tribunal with information they wouldn't have otherwise had to be made. I can give you what has seemed to me to be a textbook example of a really valuable intervention, which happened actually after I'd left the court in 2011, in a case called Human Genome Sciences and Eli Lilly. This was a patent case, and it raised a fundamental question about the application of patent law principles to the new science of bioinformatics. Now, in case some of you don't know what bioinformatics is, that is the use of computers to detect gene sequences which code for proteins which have a potential therapeutic use. And you do this by having the computer detect a new gene sequence which sufficiently resembles ones which code for proteins which have known functions, and to be able to say that there's a sufficient resemblance to say they belong to the same family, as they're called. Now, you then need further research in the lab, having got your computer results, to discover exactly what the new protein does. And in the HGS case, the new protein was said, on the basis of the computer studies, to belong to a family of proteins with various functions in connection with the immune system. But that was as far as they got. Now, patent law requires one to show that the patent article is, I quote, susceptible of industrial application. And the question for the court was whether it was enough to say that it was capable of having some as yet unascertained therapeutic function, specific only to the extent that it would relate to the immune system, or did they have to show that it was a more particular use for it? And both the judge and the Court of Appeal said that was too high a level of generality. One had to show more specifically what it would do, and not leave the other people with further research to do. Well, in the Supreme Court, there was an intervention, and in writing only, by the Bioindustry Association. And they pointed out that further research was expensive, and that a patent, or the likelihood of getting one, was usually necessary to persuade funders to put up the money. And further research would also increase the chances of a leak, which would destroy the novelty of the patent and enable a competitor to get in first. And it was therefore, they said, in the public interest that researchers should be able, so to speak, to stake out the activities of a promising protein and as their monopoly for further research. Well, what was particularly impressive about this evidence was that the association had no axe to grind as an association. Their members would one day be applying for patents and another day opposing applications by their competitors. The association simply told the facts of life in the biogenic research industry. And this evidence obviously deeply impressed the Supreme Court. Lord Neuberger said that just as it would be undesirable to let someone have a monopoly over a particular molecule too early because it risks closing down competition, so it would be wrong to set the hurdle too high, essentially, he said, for the reasons advanced by the association. So you couldn't want more of a triumph of an intervention than that. Now, that seems to me to be really the kind of case in which interventions are valuable. The cases in which interventions are not valuable is when the intervener only says more loudly what one of the parties has already said. And I'm afraid that there were several of that kind during the time that I was there. But they are, from my point of view, perfectly useless.
Thank you. And if anybody has a client who might have what you think is an overambitious intervention, then you could refer them to Lord Hoffmann's judgment in Re Child, where he talks about interveners, and that's enough to potentially scare off an intervener. Picking up on one point, Lord Hoffmann, you mentioned in the genome case that the intervention was written only. Obviously, yes, the court can give permission for oral interventions as well. Do you think that making oral interventions has a greater impact with the bench?
No, I don't, because I think that once you're into oral interventions, unless you feel that the information you've described, you've supplied in writing, is too difficult and complicated for their lordships to understand, and that you have to therefore explain it to them orally as well. Unless that's the position. An oral intervention puts you into the position of an advocate. And it seems to me that the great advantage of the Bioindustry Association was that they were not advocates, and that what they were doing was supplying information. And normally, if you've got an audience who can understand what you're writing, then that's enough. And my feeling is that probably the present practice under which the lordships decide whether to allow oral intervention or written only at the time when the application for is made is probably not the best one. It might be better to say, well, let's see in writing what you've got to say, and then we'll decide whether you should be allowed to do an oral intervention or not.
Yeah, that's very interesting, because I have to say, from somebody advising clients on interventions, I would always hope to make oral submissions. You just feel like you're getting heard more.
Yes.
But just like you just say, one of the issues I've grappled with in two interventions is the balance between giving factual input to the court and formulating legal arguments.
Yes, I agree. Yes, you're not an intervener should not be in the business of formulating legal arguments. If he feels that there's a legal argument that's not being properly put, he can write a letter to counsel for one of the parties.
Those are sentiments with which, of course, I deeply disagree, Lord Hoffmann, because every opportunity for counsel to stand on his feet and earn his meagre crust should be embraced. But more seriously, I can see that in many cases, an intervention in writing could be more useful. I just wanted to pick up on the point that you just made about interventions in relation to law as opposed to fact. Of course, many interventions do trespass into making submissions about the law, not least because one can have so many different situations where the law is going to be applied. So, for example, in the case of Times Travel, there was a case involving an entirely domestic commercial dispute between an agent and his principal about not an awful lot of money. But then along comes, in effect, Russia and Ukraine, who are arguing the law of economic duress on a sort of geopolitical stage, on a huge canvas. And they are putting arguments which are of a completely different order of magnitude, which their lordships wouldn't have heard in the context of a purely commercial case.
Yes, I think you're right, Philip, and I think it was too facile of me simply to say that they shouldn't be involved in questions of law, because after all, even the patent case involved a question of law. That is to say, when the Act says you must show it to be of industrial use, what should count as proof that it is of industrial use? And that, I suppose, is a question of law, because you're going to have to apply that kind of law to the facts. So that's true. And I think that in that sense, yes, you can make submissions, but the submissions on questions of law must be based upon some different view of what the facts are or would be if the law were one way or the other.
But picking up on another point you made, that some of these interventions are just making the same point that the parties are making, just a little bit louder.
Yes.
Of course, in Halliburton and Chubb, there were no less than 5 interveners, all of them arbitration organizations, the ICC, the LCIA, broadly saying the same thing.
Well, I quite agree. Now, I suppose probably their lordships felt that having allowed one of them to intervene, it would be rude not to allow the others to do so as well.
Yes.
But I think that was quite unnecessary. In fact, I'm not sure that it was necessary in Halliburton to have any of the parties doing an intervention, because I think the counsel and the solicitors on both sides knew quite enough about arbitration already.
Yes, I agree.
Lisa, from your perspective at which you've obviously been involved with interventions, I wondered whether you could just give your perspective on how you select cases for interventions and kind of the factors you think about when you're doing so.
Yeah, I mean, there are a lot of factors that we, and really any intervener, have to take into account before deciding to intervene in a case. And each intervener, I think, is going to have different and sometimes competing priorities to bear in mind. So what I'm saying, which considers, obviously may not be what other people consider. But first and foremost for us, we have to think about our charitable objectives. And I think it's worth remembering that which is a charity. Sometimes I think we can be thought of as those guys that tell you which washing machine to buy. And that's okay. We do that as well. But people can forget that our work and our reach extends much further than that. We exist to benefit consumers in line with our charitable objects, and we have a role to play in protecting consumers from decisions that could adversely affect their rights. So our interests lie in the wider consumer benefit, meaning that if we intervene in a case, we're not doing it as a self-interested party. So I'm quite glad that I can sort of tick Lord Hoffmann's box there, that we're not just going to do it to shout louder or to reiterate what others have already said. And I think that's important because it allows us to provide assistance to the court without becoming too entangled in the parties' cases. And while it's true we might want to see a specific outcome from a case, ultimately the decision on whether to intervene for us needs to rest on whether our involvement could benefit consumers as a whole, not just a small group. And I think I agree with Lord Hoffmann completely that the interveners have to provide a benefit to the court, otherwise why are we there? And we have to ask ourselves, what value can we, which as a charity for furthering consumer rights, offer that the other parties don't offer? And in that same vein, we've also got to consider, is this case the right one for us? But also, are we the right intervener for the case? Because we won't always be, so we've got to acknowledge sometimes when we're not, because we're not there to opine on the merits of each party's case. We're there to share the relevant knowledge with the court. So from our perspective, we'll consider intervening really only where we can offer relevant evidence and experience that goes beyond the submissions of the parties, or alternatively, if we can offer submissions on how the outcome might impact consumers as a whole, because we've got entire teams which that survey and collect and collate and report on data relating to consumer impact and detriment and benefit. So we'll consider if we can use that expertise to offer the court insights on how its decision could impact consumers. But at the same time, I've talked about the factors that affect our charitable objectives, but also we do have to think about cost. Being a charity means that resources are highly scrutinised. So a cost or a resource analysis is going to be essential for us to ensure we're using charitable resources in an appropriate and impactful way. So I think as an intervener representing the public interest, we have to be satisfied that any intervention we try to launch would be of public benefit. But when I talk about cost, I don't necessarily just mean the cold, hard cash element, because that's obviously important. But we've also got to bear in mind the human resources required, because interventions are inevitably really resource intensive. So we've got to consider, have we got the people power? Can we spare the time and the people? Or would we need to divert resource away from other important projects that also further our charitable objectives? So are we comfortable doing that? We would obviously love to do everything, but that's just not realistic. And I think you might get to this point in a bit, but factors like media management are also going to be really important, because we're a media organisation, so we're quite well placed to be able to assess whether or not we've got resource for press strategy, but not every intervener is. So it's important to ensure that you're prepared to handle media attention. Remember that public interest cases are likely to bring a whole host of interest from the public. Sometimes it's good and sometimes it's bad. So if you're considering bringing an intervention, are you equipped to produce press statements or prep spokespeople or prep journalists so that your message doesn't get lost? Are you able to shoehorn spokespeople into media interviews? Can you risk doing all of that and using lots of resource to do it, only to be bumped off the headlines because Boris Johnson's bought new curtains? I mean, it's definitely something that you have to take into consideration. We've been, I think, really lucky that we've generally found that the court's really receptive to us, and we've been welcomed by the court in our applications to intervene. And well, actually, that's not fair, that's not luck. We take a lot of time and effort to consider how we can offer the most useful submission in the most impactful way. And while the court's usually always been keen to hear from us, we haven't always had the same reception from the parties to the case. So I think where you can obtain the consent of the parties to intervene, then that's a boon, but it definitely isn't a given. So I think proving to the court that you can offer a benefit when the parties don't necessarily want you to is really key to getting that permission to intervene. And the cost analysis as well is going to be really, really important. For us, it's extremely stringent because of the charitable objectives, but we aren't going to be the only people concerned with the potentially spiralling costs of litigation. Parties have got concerns that interveners make cases longer or more complex and more expensive, and particularly if they think you're going to raise novel points or points that will require extra time for them to review and respond to. So I think the key to overcoming those concerns is definitely going to be clarity and brevity. So, as an intervener, we generally have a very limited amount of the court's time to make our submission. So it's really important that we aren't seen to be wasting time by simply reiterating what the others have said. As Lord Hoffmann's mentioned, we need to be really concise and impactful. And we need to demonstrate to the court and the parties that we're going to take steps to do that we will cover our own costs, we'll keep submissions focused, will be relevant. And if we can do that, hopefully we can go some way to alleviating some of the usual concerns. And I think one of the things that we've just been mentioning about written versus oral submissions, I think be prepared to be flexible, because obviously we all want our position advocated orally where possible as interveners, but if there are time constraints, consider if you can offer assistance by doing it in writing instead, because as Lord Hoffmann's already pointed out, sometimes a written submission is even more helpful than an oral one.
Lisa, I suppose one of the things that you have to weigh up are the alternatives to an intervention.
Absolutely.
For example, lobbying ministers or the Law Commission or other bodies that are close to the lawmaking process.
Well, if
I suppose the only trouble with that is that nothing quite has the media impact of an appearance in the Supreme Court. And that seems to matter to you a lot.
It does matter, and I think the reason for that is because of the impact that you get with it, the PR value. I think we will always consider if there is a more appropriate way of doing things. We won't just jump straight to intervention. In the last few years, we have only intervened in 2 cases, so you can see we're not going straight to intervention on every subject. But I think with PR value, it's important, it definitely is, but as any litigator knows here, and hopefully it's not too trite to say this, you win some and you lose some, but it doesn't sting any less when things don't go the way you want them to. So regardless of which way the judgment goes, if the outcome's going to have an impact, either positive or negative, on consumer rights or laws, we're going to want to raise awareness, whether that be through an intervention or through talking to stakeholders or policymakers, or by supporting someone else's submissions. I mentioned that we've got teams that have specialist expertise in areas. Maybe we could offer evidence to support that without actually making an intervention. As you mentioned, the PR value is obviously going to be high. There's going to be an obvious bonus to raising the profile of a matter. But it's important to be prepared to do alternatives as well.
If you were saying, Lisa, that as a charity, you need to conserve your resources and only intervene in cases in which you have information which you think would make a real difference to the outcome of the case, then I think your interests and those of their lordships coincide.
That's excellent to hear from you, Lord Hoffmann. I feel better about what we're doing, hearing that from you.
Lisa touched on the impact on the parties. What's your experience having encountered this very, very recently?
Well, maddeningly, my experience is that it all depends. It depends on whether you've got an intervention from somebody with a genuinely public interest, or whether one is looking particularly at interveners with consumer interests at heart, or whether you're looking at an intervention from a purely private commercial party. And in all those cases, the reception, I think, from their lordships is different. My impression is that when the all-party parliamentary group comes along and says that we want to intervene in X or Y, the fact of who they are probably unlocks the door, doesn't necessarily open it, but I think being who you are, being a representative of all-party interests in the House of Commons, must in and of itself,
and the House of
Lords, and indeed the House of Lords. Yes, we mustn't forget that.
And I belong to a couple of all-party parliamentary groups here.
But the point is that with that backing, it seems to me that yours is an offer that is pretty hard to resist. I can see that in the case of an organization like Which, the same applies to an extent, perhaps not to the same extent, because their lordships may think that the ground's already covered by the parties, or that the case isn't the appropriate one. In the case of purely private interests, then that seems to me the mountain that is the most difficult to climb and to justify, because I think, as Lord Hoffmann has said, you've got to be able to satisfy the court that you have actually got something to say that the parties aren't saying already, or you've got an interest that isn't going to be properly argued by the parties before the court. And my own experience is that by the time you get to the Supreme Court, you've got advocates who are of equality, who are going to cover the ground, and their lordships are going to expect a very full analysis of the issues, making it relatively unlikely that private parties need to have their arguments supplemented by others. Now, as I've already mentioned, in the Times travel case, it was two ends of a very, very broad spectrum. You know, there were two states in effect arguing about the geopolitics of Russia versus Ukraine, whereas Times Travel was arguing about its agency for Pakistan International Airways in Birmingham. Two ends of the spectrum. But actually, what happened in Times Travel was that the intervention seems to have been inspired by their lordships rather than by the parties, because they could see that these two cases were proceeding and that the same broad issues were being discussed. If anybody wants them, my top tips for interveners are: 1, be astute to establish your credentials. Some people don't need to, but nevertheless, be astute to establish your credentials for the issues in question. Secondly, never offer an unlimited role in the appeal. Have your eye on the ball of what it is you want to say and why you want to say it. Thirdly, always be prepared to fall back on purely written submissions, because those are far easier to sell than oral ones, because everybody knows that counsel love the sound of their own voices, and once they're on their feet can only be contained by the more forceful of their lordships. But the modern practice seems to be that that when oral submissions are permitted, one is given a pretty strict time limit for how long you will be permitted to talk. And the ones that I've seen have been reminded in pretty clear terms when their time is up. The fourth point is a more general point, which is avoid overkill. And of course, the best recent example is Halliburton, where there were 5 parties essentially saying the same thing. I mean, one of the parties would dispute that they were saying the same thing, but in the event, 3 of them were permitted to make oral submissions, and 2 of them were not. Lastly, be absolutely clear about what line you're taking in the intervention. Because if your line isn't clear and it isn't expressed as economically as possible, you're doing everyone a disservice, not least of all your own interest. Given how expensive litigation is, and given how other parties who have doubtless spent large amounts in getting to the Supreme Court and have calculated that the Supreme Court's an appropriate place to take their case, don't want to sit through a lot of irrelevance, nor do they want to be burdened with disparate submissions which are of no help to anyone. So pick your fights with care.
Can I point out that the fact that the decision of the Supreme Court will affect a large number of people, the public generally, and so on and so forth, or even that it will affect some particular person who wants to intervene, it cannot possibly be a ground in itself for intervention, because the criterion for giving leave to appeal to the Supreme Court is that it raises a point of general public importance.
Yeah.
And if that was sufficient, you would give leave to intervene to everybody in every case.
I think one of the things that
interesting, Lord Hoffmann, when I look at the recent judgments featuring interventions, some of them engage with the intervener's arguments in a lot of detail, like the genome judgment you discussed, or indeed Halliburton and Chubb, where actually they do talk about the interventions in a lot of detail. Quite a lot of them barely mention the interventions at all. And of course, in each of those, the intervener was given permission to intervene. So presumably they were thought to have some value. I'd be really interested in your views on the extent to which an intervention is dealt with in the judgment reflects how much it actually influenced a panel when they were writing the judgment.
I don't think you can set any store by that. For one thing, the people who hear the argument in the end are not necessarily the people who gave leave to intervene. And nor are they the people who gave leave to appeal. And I've sat in a number of appeals in which we've all asked each other who on earth gave leave to appeal in this case. So that isn't a sufficient reason. And some people writing their judgments, having heard the intervener, are more polite than others. So I would attach no importance at all to the fact that they say nothing about people or they mention them in a perfunctory sort of way. But if they actually acknowledge that they received particular help from it, well, that's another matter. But I think you'll find that those are rare.
They are.
I think one of the interesting comparisons that one can make is, and I was very interested in Ned's figures of 16 out of 53, 21 and 8, that in the US, in the Supreme Court, interventions seem to happen almost as a matter of course.
Aren't you allowed as of right? You're allowed as of right in the US to appeal to intervene. I don't know.
Do you think that's no? I think in the Supreme Court that I'm unsure as to the answer, but I'd understood that it was a permissive regime, nonetheless.
Yeah.
A very permissive regime for interventions.
Right.
But bearing in mind that in the US Supreme Court, the opportunities for advocacy are very limited.
Yes.
Usually to 30 minutes. But I wondered, Lord Hoffmann, if you thought that that we ought to go the same way as the United States and allow a lot more interventions.
No, I certainly do not. One constantly reads about people putting in extra briefs in the appeals in the United States Supreme Court, dozens of them, as far as I can make out. And one wonders who reads them. But I think the criteria which the court has at the moment for granting leave is quite sufficient.
A follow-up on that issue. You were meant to apply for permission to intervene 10 weeks before the hearing, which really isn't very long, especially as you have to apply 10 weeks before, but you might get permission to intervene closer to the time. And what that means is you may well get permission quite close to the hearing, and there isn't, for example, an opportunity for another organisation in the same area but with a different view of life to intervene. And I suppose when I think about the all-party parliamentary group on fair business banking being pro-bank consumer, you can think of different viewpoints, and I would have thought for which you might think of business interests which might have different viewpoints. Do you think that there is an argument in favour of ensuring that if there is going to be an intervention, it's a more balanced one, or that there's an opportunity for anybody who should intervene to intervene.
Well, I think it's essential that, first of all, the council should have, of the top of the parties, should have adequate notice of what any intervener is going to say. That you should have. That's why I think it's a good idea that they first put in writing what they're going to say, and if necessary, that be given to the existing parties, and only then does the court decide whether or not they're going to be given leave to intervene orally. But I said, yes, I agree. I mean, I think it would the printed cases of the parties, I think, are published in advance of the hearing, and I don't see why the statement of what the intervener is going to say shouldn't be likewise published in advance of the hearing.
Ned, in the case of the all-party parliamentary group, is it fair to say that if you ask to intervene, you will almost certainly be permitted to?
I have no idea. Why should the APPG get a free ride?
I think Lord Hoffmann's much better placed to answer this than me.
To tell you the truth, I was astonished at the notion of any APPG applying to get leave to appeal to intervene in a hearing in the Supreme Court.
I must say we were very conscious that it could be said, well, you have a unique ability to ventilate something in Parliament in both houses. So if anybody shouldn't be coming before the Supreme Court, it's you. So we were really quite sensitive to that issue.
Yeah.
But I suppose, just like Nisha says, you just have to pick your interventions very carefully. And in both cases, they were topics that the APPG had looked at in a lot of detail and had a huge amount of experience. So that it was really that experience that we wanted to bring before the court.
In what sense did they have experience?
Well, the input the individual MPs and Lords get from constituents who have suffered from. Yeah.
I understand.
And I think that's valuable from Which's perspective as well. When we're intervening, quite often we're providing a voice for people who aren't part of the claim itself. So being able to step into the middle and be this sort of impartial voice, and in our case we're the voice for consumers, but we have access to what consumers are telling us by virtue of what we go out actively looking for answers to certain questions, and if we can collate that information and provide it to the court in a way, they may never have had that information unless we provided it to them. So I do think that there's definite value in certain groups being able to talk to the court and provide information to the court that they might not hear from parties that actually have skin in the game.
Yep.
We have a question which I'd like to squeeze in because it's an interesting one, and I'm sure you'll have a view, Lord Hoffmann, given your practice as an arbitrator. It is whether there's a value in interventions by potentially affected third parties in private arbitrations.
No, I can't think of any. Private arbitrations are confidential. There shouldn't be a third party who's asking to intervene. And with private arbitrations, it's difficult enough even to join parties whom one or other of the parties to the arbitration would like to join, because they're not parties to the original arbitration contract. And as between the parties to the original arbitration contract, that's confidential.
Yes, I have to say that was my instinctive reaction too. I think it'd be quite hard to work out how you could know about it to intervene.
Right.
Excellent. Well, a final thought, please, as we get close to 7. Like Philip said, in the US, there are a much higher rate of interveners, both much higher rate generally, and very, very usually more interventions from a whole range of parties. Lord Hoffmann, I think you said that isn't something that you favour developing at the Supreme Court. But I did think that the concept of the Supreme Court replacing the House of Lords was to give ability for public interest issues to influence the common law. And certainly when we were just discussing Which's motivations for intervening, or the all-party parliamentary groups, that's our aim really, to try to bring in issues that wouldn't come into play otherwise. With that in mind, I wonder whether each of you would offer just a couple of closing thoughts about the future of interventions.
You're asking me?
Yes, please.
I'm not conscious of any change of policy as a result of the Supreme Court coming into existence. In fact, as you probably know, I've never been a member of the Supreme Court, so I don't know what's happened there. But it does seem to me that from the point of view of getting an answer to an appeal expeditiously and with the best possible information, the criteria currently being applied to whether an intervention should be allowed are perfectly adequate and sensible, and indeed were the same in the time when I was there in the House of Lords. So I really can't see that there's any justification for making a change to the way in which the system works.
Thank you.
I can come at it from an intervener's perspective, and I can sit here and sort of quite smugly tell you that each time we've tried, we've been given permission, so it's clearly working for us. But I think there's definite benefit to interveners, and of course I would say that I am one. But I do think that we need to try and avoid situations that we've discussed here, where people are not intervening to be that neutral voice in the middle. They're intervening for another reason. But I also think that the system as it is helps to prevent that happening. We put a huge amount of effort into getting our submissions accepted in the first place, but into getting our applications given permission so that we can intervene. We don't just do it in a sort of willy-nilly fashion where we try and intervene in absolutely everything. We're very targeted in what we do. So I like to think that we get permission because we pick the right and opportune moments. I want to see more interventions from Which's perspective. If there are situations that we think need highlighting, we're going to try and do that. But I also think that we're there to be in the consumer interest, but there's benefits in putting yourself out there and being vocal about matters that concern you, even if the case doesn't necessarily go your way. So for us, by being a strong consumer voice, we're sending a message that we're prepared to take action, including litigation where we need to. And I think that awareness leads to more opportunities for us to have a positive impact for consumers in the future. By doing interventions, we have definitely built more productive relationships with law firms and counsel and others who approach us with examples of consumer detriment, or who are happy to work with us on things we uncover because they know we're prepared to step up to the plate where needed. So I definitely want to see interventions continuing. But I agree with Lord Hoffmann. I think it's working the way it is right now.
Thank you.
Well, from my perspective as advocate, I think that the genie's now out of the bottle, if ever it was in the bottle, in the sense that it is no longer remarkable in Supreme Court cases that parties intervene. I think their lordships are getting relatively used to the idea of intervention, and that although the test for intervening has remained the same, for a long time. I think the way that the test is being applied means an increasingly receptive response from the Supreme Court. But there is one important point to be made, I think, and that is that interventions are not always helpful, and that is that they can increase costs, they can lead the law off into a tributary that it didn't necessarily need to explore, and that for the most part our adversarial system works pretty well without parties who aren't interested in the dispute itself coming along with their own perspectives. It does introduce for an advocate a very different dynamic. You're not just fighting the other side. You've got, as it were, there is another party putting what could be a different spin and a different perspective. I like interveners, in short, provided they're on my side.
Well, if there's been a change in attitude, Philip, you're the best person to know it, and you've certainly got more information than I have.
And for what it's worth, just because you put in an application to be an intervener, I mean, it goes without saying, you don't automatically get permission. With our application with Merrick's and MasterCard, we weren't the only ones to apply. I think there were perhaps five applications to intervene, and only one was given permission. So the court was definitely exercising some sort of caution as to who they were letting through that net to actually offer up information between the parties.
Good.
I think my observation would be, based on the couple I've done, is that I think the real value is when you bring in real life experience to shape the law. And in the reflective loss judgment, Severe and Merrick's, we intervened. And what we effectively said was, well, this is an elegant, bright line rule that really doesn't work in practice. And when you look at how guarantors and business owners and creditors are affected by it, it's very nice legally, but it doesn't work in practice. And actually, when I then saw the judgment, I thought that the court had acknowledged that. And maybe they would have come to the same conclusion without our intervention, I'm not sure. But I did think that there was a value in bringing that before the court rather than just focusing on pure legal argument.
And are you saying that that's something that neither of the parties would have known about or would have said?
I think the arguments could have been made. I think the all-party parliamentary group had lots of experience of small business owners being affected by the rule negatively, which helped.
Yeah.
Well, a party could have made that argument. I just don't think that they did.
Yeah. Okay.
Well, we are at 7, so I'd like to say thank you very much to Lord Hoffmann, Peter Webb, Philip Shepherd, to Disputes Week and Brick Court for putting us on the programme, and to the audience. Thank you. Good evening.